All right, a very blessed afternoon, East Africa. Ladies and gentlemen, esteemed guests and fellow innovators from across the continent, welcome to today's webinar titled ADR in IP Disputes, the Smart Way to Protect Innovation and Avoid Litigation. And this is hosted by the East Africa Law Society Intellectual Property Committee. And my name is Gabriel Achaye. I am honored to introduce this segment right here at the Secretariat in Arusha, Tanzania. And as we gather today, we set out to explore this very wonderful world of alternative dispute resolution and the transformations it's making in resolution of intellectual property conflicts, offering a more faster, effective, and collaborative solution to safeguard innovation in a rapidly evolving world. Today, I'm honored to have an exceptional panel of experts that will be guiding us through this discussion. I'll start with the first panelist, who is Advocate William Ernest Kivuyo, a doctoral researcher at the Nelson Mandela African Institution of Science and Technology with a master's in intellectual property and over a decade of experience as a senior legal counsel. William has made significant contributions in human rights and IP law, particularly in East Africa, and he's served as lead counsel in landmark cases before the African Court on Human and People's Rights and the East African Court of Justice. His expertise is in sustainable agriculture, seed sovereignty, and traditional knowledge. And today he will offer his unique insights into ADR's role in protecting intellectual property. What a diverse portfolio, Kivuyo. Karibu sana. Thank you. Say a quick hello to our participants.
Thank you for that compliment and very good introduction. Thank you, everybody. I'm ready for the discussion and I'm waiting to hear from others as well. Thank you very much.
Amazing, amazing. It's so good to have you here. Our next panelist is a very, very respectable practitioner all the way from 254. And ladies and gentlemen, I'm talking about Advocate Patroba Keka, who is advocate of the High Court of Kenya. He's legal officer at the Kenya Industrial Property Institute, and he specializes in intellectual property, technology law, and we are privileged to have him as our chairperson of East Africa Society Intellectual Property Committee. He is a prolific writer on IP matters. If you have not read his papers, please go out there and read them. His practical expertise in handling trade disputes and his passion for innovation reach our discussion on ADR strategies this afternoon. Karibu Mother Patroba. Good afternoon from Nairobi. How are you doing?
Good afternoon. Welcome to this auspicious session. I can't wait for us to interact and we share knowledge. Nobody knows everything. Let us learn, and karibuni nyinyi wote sana.
Thank you so much, Patroba. Interact, share knowledge, and learn. Thank you. We look forward to this wonderful session. Our third panelist is Mr. Pius Ntanzinda Nkunda, all the way from Kigali, Rwanda. Mr. Ntanzinda is managing partner at CM Advocates Kigali, Rwanda, and he has a focus on IP and technology law, and he advises both national and international clients. He's a key member of the African Law and Tech Network and Rwanda Blockchain Association. His tech-savvy perspective and deep understanding of IP in the digital age will shed light on emerging challenges like AI and NFTs. Mr. Ntanzinda will be joining us later, but now allow me to go to a very special panelist who is joining us all the way from WIPO in Geneva. And gentlemen, that is Mr. Leandro Toscano, who heads the Business and Development and Digital Contents Dispute Sector at the World Intellectual Property Organization in Geneva. He has LLM in International Dispute Resolution from Queen Mary University and the University College of London, and he has extensive experience in IP, technology law. And today, Mr. Leandro brings a perspective on how ADR can address complex drawing from his work at WIPO and his prior practice in the private field. Mr. Toscano, a very huge welcome. Welcome to East Africa Law Society. We are honored to have you this afternoon.
Hello, Gabriel, and hello, everyone. It really is my pleasure to be here today representing WIPO in this wonderful seminar. So thank you very much for your kind invitation, and I look forward to discussing with my fellow panelists about ADR in IP. This subject is, my passion, and that I would like to be able to spread the word about in this seminar today.
Thank you, Mr. Toscano. Talk about a passionate man. They're talking about Toscano. It's good to have you this very lovely afternoon. Thank you, Brighton, our webinar session. Now, ladies and gentlemen, the host of this session, very good friend, Miss Brenda Imelda. Brenda is going to be our moderator. Brenda is our chairperson of the East Africa Law Society Young Lawyers Committee. She is a prosecution counsel at the office of the DPP in Kenya. She's a member of our intellectual property committee. Wow, talk about diversity, Brenda. Welcome.
Thank you so much, Gabriel. Good afternoon, everyone. I will be your moderator today. Maybe, Gabriel, are you done? Can I take over now?
Yeah, please.
Okay.
You have free range.
Okay. Thank you so much, everyone. I'm truly excited to be moderating this session and to be in the company of such experienced experts, both from the global and the East African legal landscape. And today, as young lawyers, we are entering a professional world where innovation is moving faster than litigation can keep up. And which is why this is where ADR comes in. And the goal of this webinar simply is to equip us, that being the young legal professionals, with practical skills to resolve IP dispute without the courtroom battle scars. So we'll get right into it. If you have any questions, please remember to just put them in the Q&A toolbox, or you can just write your questions to the panelists on the chat box. They are at liberty to respond there and then, or during the Q&A session. So thank you. So we can start with Mr. Toscano. Maybe you being at WIPO, WIPO has a bird's eye view of the global IP dispute. Maybe from your vantage point, you can tell us the most significant trends that you're observing in how IP disputes are handled through ADR.
Thank you very much, Brenda. So let's start from the beginning. Let's start talking about why ADR for IP disputes. No? We always want to understand the needs of the different sectors and try to find the right solutions based on these needs. So what we observe is, of course, IP is, first of all, it's a very specialized area. So we need to have experts that understand not only the legal context, but also the industry practices. And sometimes the national courts may not be equipped to deal with this. So ADR is it's one of the tools that are available to resolve disputes in this area. We also have to bear in mind that IP has become more international, both from the sense of the creation, more international collaborations to create IP, for example, research and development. The use of IP, of course, has become a lot more international in recent decades, in particular with the expansion of the internet and the digital environment. Well, any work that is created like music or audiovisual can be transmitted and used in different parts of the world instantaneously in seconds. So we need to have solutions that are international, that are not constrained to local jurisdictions. And ADR is a very good example of that, when you can have parties participating from different parts of the world to resolve IP disputes. We observe here at WIPO about 70 to 75% of the cases that we receive involve parties based in different jurisdictions or rights that are protected in different countries. So that's why ADR is also a very useful tool to deal with these international disputes. Confidentiality is another important element. And for that, for example, the WIPO mediation and arbitration rules have very strong provisions on the preservation of confidentiality of the existence of a dispute, the content of the proceedings, and of course, the outcome. So if you're dealing, for example, with trade secrets, then ADR can be a very suitable solution for this. And of course, time and cost that are usually ranking very high in terms of the preferences and the issues that one has to keep in mind when choosing a dispute resolution option. We know that in terms of time, litigating in the court in different jurisdictions may take different time, but it could be quite a long process going through different instances. If you have a first instance, an appeal process, or any other stages. And of course, in terms of cost, also, this could be quite impactful. So ADR has the objective of minimizing cost and making a very time and cost efficient procedure to resolve disputes. So these are some of the basic elements and considerations to keep in mind when choosing ADR. Now, in terms of trend, we observe an increase in the use of WIPO ADR services. This is very much linked to the, I would say, first of all, more knowledge, more awareness. So from around the world, and we have the chance to work in all regions in the planet. So we can observe an increase in the promotion, the acceptance of ADR as a mechanism to resolve IP disputes. So that translates into an increase in the caseload, the number of cases that are filed with the Arbitration and Mediation Center. Then there's another important consideration, which is the involvement of government institutions in the promotion and the delivery of ADR services. And for that, we have a few brilliant examples in Africa, for example, where we work with copyright offices in Kenya and Tanzania, just to give you a few examples, as well as industrial property offices in Namibia, where the offices, in collaboration with WIPO, offer these mediation services that are provided by staff of the office. So we participate in the training of staff to become mediators. These services are provided for free or at a very low cost, so they're accessible by all kinds of stakeholders in the IP world, from creators, inventors, entrepreneurs, startups, SMEs. These are the main users of ADR. Well, before, perhaps in the past, the procedures were more or mainly used by international and multinational corporations with deeper pockets. So nowadays, we observe a trend towards the use by small and medium enterprises and individuals, as well as collective management societies. So this is a lot more, let's say that the barriers of access are much lower than what they used to be. And again, the role of government institutions is very important. There's policies to promote ADR and to provide the dispute resolution services. The legal context also has evolved, and we observe changes in legislation at the national, regional, and international level. So, for example, new copyright laws or trademark laws include mentions and the possibility of referring disputes to ADR, for example, in trademark oppositions, to perhaps suspend the procedure before the office and try mediation to try to resolve the dispute, as well as the referral of cases pending in the courts to ADR. We observe in the case of Tanzania, we collaborating with the judiciary to provide tools to offer parties to participate remotely in hearings. So this is a very useful tool in cases, the parties don't have to go to the court in person, but they can participate online, and this has increased the level of participation, especially after we went through the COVID pandemic, when we all got used to using these remote tools for video conferencing, and now we see this also implemented in the courts as well as in ADR procedures. So legislation, as I was saying, it's also very supportive of ADR. We saw a few years ago the conclusion of a new international treaty known as the Singapore Convention on International Mediation, which will have similar effects to the convention for arbitration known as the New York Convention, that it's been around for a long time, since 1958. So this new convention on mediation will encourage the use of mediation for commercial disputes, including IP matters. And in a regional context, we can observe, for example, in the European Union, new legislation like the Digital Services Act that regulates the, let's say, the work of platforms, of online platforms, the obligations in terms of the possibility of offering parties to resolve IP disputes when content is used in online platforms, referral to out-of-court dispute resolution systems. So all of these trends that we observe allow us to conclude that ADR has become more popular, and that the benefits of ADR are very much appreciated by the IP communities. And that's why it's important to continue spreading the word in forums like this one today. And well, of course, we could say a lot more about this, but I'll give you the word back, Brenda, to continue with your questions.
Thank you so much, Mr. Toscano, for that. So maybe now we can go to Mr. William. Given your experience in IP in the region, have you seen an increase in the use of ADR mechanisms like mediation or arbitration for IP disputes? Maybe you can talk to us about that.
Oh, thank you, Brenda. So my experience, and maybe basically to Tanzania experience on IP issues. Maybe we should also about just mention IP is copyright because aspects of IP that normally come under ADR. And in Tanzania, the IP resolution by way of ADR it's actually growing. It's growing. It's a growing area. But generally, IPR dispute solution is preferable because of the cost effectiveness when we compare to litigation. It's preferable because of the confidentiality. It maintains confidentiality. There's a speed. There's a continued business relationship. In normal litigation, normally it is one party that takes all. So the one who is losing remains frustrated and angry all the time. So the business relationship is not kept. Unlike in ADR where you can shake hands and you can go on with the meetings. With the growing trends on dispute solutions generally, there is a spirit, this that wave moving, where the different nations are changing the laws to uphold ADR. Through mediation, through the High Court, we have what is called court annexed mediation, where a court case is filed, and then before it goes to trial, it is a requirement that parties should attempt to resolve through mediation. So that is court annexed mediation, which has been there since 1995 in Tanzania, and it came up to 2020, where we changed our law, and now the country is moving toward having all aspects of ADR practice. And again, not only in court through the so-called court mediation, but now they are going to allow ADR outside of the court system. That you can now have negotiators, you can have independent arbitrators, you can have mediators out of court mediating these matters. So we see this as a positive movement, and we have a change of law. Our laws were changed in 2020, and we have a new law. We started with the Arbitration Act, and this act allows this kind of disputes to be undertaken in a wider spectrum. You can have a negotiator, you can hire a negotiator, you can choose an arbitrator of your choice from outside the court. But again, you can actually do it from whenever you want and do it in any country, in any part of the world. So there's that flexibility with our new law. Now, with at the level of Africa, we know that East African Court of Justice has a component of ADR as well, and it is working, and especially in the mediation section. So, generally, we are moving toward having that spirit of embracing ADR, and being into litigation, which is really costly, time-consuming, and highly frustrating, especially in most courts in Africa, where this can take up to 3 years. That is for example, trial alone. If you go to the first appeal, it may go another 2 years. So I have cases where from the first court, the trial court, to the highest appellate court, a case has taken 10 years, 10 years. And actually, as I speak, it is still not out of court. We are expecting that will be finalized this year. So it's 10 years, it has been in court for 10 years. You can imagine the losses, the economic loss that comes with that. So ADR is something to embrace, and really it's a very good thing. So in IT as well, it is important to have them, especially for Tanzania and most probably for East Africa, especially in patents, trademark, and copyright. These are common cases that we find, and we see them having people parties appreciating ADR. Mediation may not be that much, is a bit less. We see businessmen like to go for arbitration, maybe because they have deep pockets, as my colleague said. But mediation and arbitration are really picking up in the region. Brenda, if I may end up there, and if you have any other questions.
Okay, thank you, Mr. William. I think there was a bit of concern on your echo. There was an echo and background noise from your end. Maybe you can check on that. But thank you so much for that insight. It's good to know that court and next mediation is encouraged also, or the other. In you're practicing it in Tanzania. I think also Kenya, we encourage it a lot. Thank you so much for that. So for Mr. Patroba, maybe you can tell us as a young lawyer in IP, some of the practical skills that you use in handling IP disputes at KIPI.
Thank you, Brenda, for that question. Every day at KIPI, we normally handle various disputes. And these disputes mostly are really focused on trademarks. If you look at the registration process of a trademark, we normally have the window for publication in the journal. So once before we give a certificate of trademark to a client, or rather, let's say a company, what normally happens, we normally put it in the journal, whereby anybody who has an opposition to that mark can be able to come forward and say, this mark belongs to me, or this mark is similar to mine, or rather this mark is being registered in bad faith. And it is these are disputes that always happen. But again, as a legal officer in that area, once that happens, I must be able to have knowledge of what a trademark is, what are the features to look at when registering a trademark, and after the opposition has been made, I will be able to assess, I will be able to look at the legal ramifications and the legal implications, both of the opposing side and the applicant, and I'll be able to give a decision that will either give a go-ahead of the registration or issuance of certificate of that mark or not. Now, it must be noted that we are basically somehow of a quasi-judicial body. So if anyone will not be satisfied with maybe my decision that I have given a go-ahead of registration of their trademark or a patent, they are at free will to go to the High Court. But in most times, we are normally dealing with the ever-evolving innovation, because we cannot have a monopoly of a company. For example, there was a medication that was called Fastum that was used to treat wounds of people who have been injured in sports. And there's another company that came up that was called also Faster, and they began warring amongst each other. The same products are used for the same activity. They are normally applied on wounds, and I can imagine denying a new company that has is into innovation registration. I felt like maybe it would be unfair. So I gave a go-ahead that they may continue and register their company. So these disputes normally happen every day. And for the sake of innovation, most of my decisions, I normally agree for registration of so many trademarks and patents. And sometimes parties may not be happy, but for the sake of innovation and IP, I normally allow them. So those are some of the skills that we use to deal with the disputes. And also sometimes we may be able to, we might ask also for advice from WIPO. We might even ask for advice from ARIPO when we are trying to register various trademarks, or we are trying to revoke some certain registrations. Yes, basically that is what we deal with every day. But we normally focus really on trademarks when we are dealing with disputes, because we have so many industries that are coming up doing similar businesses. Thank you, Imelda.
Thank you, Mr. Patroba. So maybe you can go back to Mr. Toscano. And maybe can you please walk us through a typical IP mediation or arbitration case progress at WIPO, so that we can get insight on how it works at the center?
Great, thank you, Brenda. So first of all, of course, we need to remember that ADR is consensual, right? So we need to have all the parties on board. Everybody has to agree to participate. This could be done in different ways. So you could, for example, in a contract, let's say a licensing agreement for a technology or for a song or for a video game, you could include there a clause, a jurisdiction clause, where you choose with the other party, you agree that if there's any dispute in the course of the collaboration, then you would go to WIPO ADR instead of going to the courts. That's a typical way. But what happens in cases where you don't have an agreement with the other party, or the agreement includes a different provision? So in a situation, for example, where both parties are in a dispute and want to refer a case to ADR, for example, a court case, when there's a case pending in the courts, or in a situation where the parties are negotiating and they think that they need the support of a mediator, then they can agree and sign what it's called a submission agreement, which is a simple document just indicating their willingness to move to mediation. In the case of arbitration, I would say that the big majority of cases come from contractual disputes. So the threshold is higher if you need to agree with the other party to refer a matter to arbitration once the dispute is there. So it's more common to see cases when there's already a clause in a contract. There's also the possibility of inviting the other party through WIPO to consider mediation. So that's what we call the unilateral request. So basically, a party, for example, in an infringement situation, when a party finds out that the his or her IP rights are being infringed by another party, and they would like to maybe try to regularize the situation, maybe have an agreement, a licensing agreement, and instead of just like going to the courts or getting a cease and desist, for example, letter, so they could, through WIPO, contact the other party and offer the possibility of getting together, of exploring solutions through mediation. And of course, the other party is not forced to participate. So if the other party does not participate, then the case is terminated. But otherwise, the parties can continue and engage in these discussions, also known as deal mediation. So trying to negotiate a contract and agreement with the help of mediation. So that's the base to start. Then let's suppose that there's an agreement and the parties included in a contract a clause, and there's an issue, there's some breach of contract, there's someone that is not paying royalties, or there's any other discussions, and one party decides to initiate proceedings. So the process is quite simple. WIPO has mediation, arbitration, expert determination rules that indicate all the documents that need to be filed to start the case, and that is all sent electronically, so there's no need to send copies in paper. That's all included in the rules. Typically, parties will file through the online forms or by email. And then here at the Arbitration Center, we are a group of 60 lawyers from different jurisdictions that speak different languages, and that will be able to assist the parties. Some of the staff of the center will act as case managers, so they will be in charge of that case, and they will guide the parties through the process, the documents that need to be filed, and then we will take a role in assisting the parties in the appointment of the mediator or the arbitrator. So of course the parties could agree on someone directly, even if it's someone that is not in the official WIPO list of mediators and arbitrators. If they trust someone, then of course that's a better solution, because both parties will be on board to appoint a candidate. If there's no agreement, which is what usually happens in practice. Then WIPO has a procedure in the rules, will send the parties, first of all, request the parties to provide comments on the qualifications of the neutral to be appointed, in nationality also. And after that, we will look into our database of over 2,000 experts from around the world. So we are not at WIPO the mediators of arbitrators, but we have external mediators and arbitrators that are normally lawyers in practice. It could be university professors and also technical experts like engineers or other professions that might be needed. So we will then provide the parties with at least 3 profiles for them to analyze, and the parties will return they will rank the candidates and will return the rankings separately, and we will put the rankings together, and this is how we will end up with the most acceptable candidate to be appointed. So then after the candidate is appointed, the mediator or arbitrator will get together with the parties. They will have a preparatory conference. Well, they will discuss the ground rules. They will discuss the calendar. They will come up with an agenda for the case with the different deadlines, depending on the case. In the mediation, things are a lot more informal and it's simpler in case of the submissions, while in an arbitration, we will have a more like court-like procedure with different filings and evidence and witnesses and hearings, etc. So that will be coordinated among the parties, WIPO and the arbitrators or mediators. There will be also, in the case of the fees that are applicable to the experts, the fees will be adapted to the circumstances of the case and the parties. If we are in a case where we have 2 individuals or 2 SMEs, for example, of course, the fees will be adjusted to the reality, so they will make sense in terms of the dispute, of the amount in dispute, for example. After all the process is concluded, then the parties and the mediators arbitrator will have their hearing or the mediation meeting, and then there will be a solution. In a mediation, you can reach a settlement, so the mediator is not going to impose any solution, of course, but it will help the parties to reach a settlement. In 70%, 70% of the cases that we see at WIPO mediation, the parties find a settlement, so the percentage is quite high. And in arbitration, you will typically have a decision being rendered by the arbitrator. This is known as an award. We also see that in about 30% of the WIPO arbitrations, the parties reach a settlement before the dispute is decided by the arbitrator. So there's a lot of room for settlement in IP disputes. There's a lot of room for collaboration, for renegotiating terms and conditions. Of course, it depends a lot on the type of dispute. If you are in the case of an infringement, or if you are in the case of a breach of contract, the situation can be quite different. But this is how typically a case will be conducted. The parties get a lot of support from WIPO, from the case managers. The idea is to remove all the administrative matters from the parties and the tribunals or the mediators, and to support them in all this logistics, so they can concentrate on the resolution of the dispute. So that would be, Brenda, how a case typically works at WIPO.
Oh, okay. Thank you. Maybe we can go to Mr. William. I don't know if your audio is okay right now.
I don't know. Can you hear me well now? Is it better?
Okay. Maybe can you repeat that again? Can you hear us?
Oh, is it better? Is my audio better now?
Not quite, but I can.
Brenda, can you hear me now?
Okay, it's a bit better. I don't know, maybe.
A bit better.
Yes, it's a bit better. Yeah, thank you. So maybe you can tell us what is your biggest. maybe you can tell us your biggest concern when it comes to maybe advising a client on IP disputes when you're trying to refer the matter maybe to ADR, some of the challenges that you can face in such a situation, because some clients maybe do not want to go for ADR when it comes to this. So how do you go about it? Maybe you can share your experience with us.
Thank you, Brenda. My biggest concern when it comes to advising a client for ADR is on on is on is on implementation. We have challenges when it comes to implementation. The culture of ADR is kind of not that much supported. There are parties who avoid ADR. It's like parties just like going to court. It's like it's a way, there's that spirit of kind of wanting to kind of punish the other party. So you advise a client and they don't like it. They look at it like this lawyer maybe is not competent, this lawyer maybe is terrified, is terrified by the other lawyer from the other party. They look at you as a soldier who is not prepared for the war. So they are not impressed. That is one. But again, there is limited support from legal practitioners. Lawyers like to go to court. They love that debate in court. They like that tug of war, that battle of words in court. So they don't like it. Another challenge is that we still, in our context, and Tanzanian for that matter, we have limited understanding of ADR by the population. People are not aware of the benefits of ADR, so they don't really grasp the essence of it, so they don't like it. But again, another challenge is the limited number of trained mediators, trained negotiators, trained arbitrators. You may have someone calling himself a mediator, but ending up doing arbitration. I had a case in the East African Court of Justice where it was supposed to be mediation, but at the end of the day, we recognized, we realized it was really the one whom we thought is the mediator was doing arbitration. So there's that limited training on the arbitrators and mediators. But again, in the African context, we have limited resources. You need resources. For example, mediation. These are parties who have been, in disagreement for a long time. They sometimes they have feelings, heated emotions. You need an environment. You need a conducive environment. For example, in Tanzania, there was a case in point where the government wanted to put a mediation center within the court premises. And then we intervened. We said, no. It's not going to be mediation. We are bringing in the minds of the parties. They will be thinking that.
Mr. William, we've lost you. Can you hear us? It appears Mr. William is experiencing challenges with his device. So maybe Mr. Patruba, I can see there's a question for you in the chat box. It says, you have noted that many IP disputes arise from SMEs or informal sectors. So how can ADR processes be made more accessible and trusted by these groups in Kenya? Do you want to, maybe you can answer that question? It's from Edward Kibe.
Yes. I agree. Most of these disputes normally come from SMEs. And even if you go to the Kipi journal right now, you will find that most applicants for trademarks are SMEs, because these are upcoming companies that are trying to register their trademarks, and they're upcoming, trying to get into the business market. So we also need to realize that as much as we are trying to avoid the litigation route, sometimes ADR is the best option. And ADR, Imelda, please repeat the question, please. I might have lost my thought process.
The question is, you have noted that many IP disputes arise from SMEs or informal sectors. How can ADR processes be made more accessible and trusted by these groups in Kenya?
Yes. What I noticed is that most ADR bodies which involve mediation and arbitration, mostly they are not advocates. The majority are now not advocates. I have come to realize that most of them really have not undergone either any advocacy trainings, but they are more of outsiders who are now into ADR, and they have opened many. They are normally in court there. So you find that the moment one has referred a matter into ADR, in most times we find that these matters are normally dealt with in a manner that the outcome may be pleasing or may not be pleasing. But again, we must look at the cost efficiency. That is what most parties are looking for. That is why there's accessibility to them. We look at the cost efficiency, whereby parties want to avoid high costs. We must look at also the speed for ADR, because when we have a reasonable speed of dealing with matters, we are able to put that aside and we proceed with our innovation in IP. There's also the issue of confidentiality. The ADR proceedings are typically confidential, which normally helps both parties protect sensitive business information. If we go the litigation way, it is normally in open court in most times, and most people will have access to that information. But also we must look at the preservation of business relationships. ADR, particularly in mediation, it normally allows creative solutions that preserves business ties. You can imagine where we have a business relationship that is constrained because there are two entities that are doing the same type of activity or doing the same type of production of products, and they end up having a business relationship that is constrained. At the end of the day, both parties may go at a loss. So those are the things that we look at in ADR, and its benefits and its outcomes.
Thank you, Mr. Patroba. I think for Mr. William. Mr. William, are you back?
Yes, Brenda. Can you hear me, Brenda? Hello, Brenda.
So I'm saying now we can hear you. We had lost you for a moment there. Maybe you can continue with your statement.
Okay. Sorry, I don't know where I lost you, but I think last time I was talking about. I was talking about the challenges that that come with ADR, and I talked about limited support from the legal practitioners. There are practitioners who don't like ADR, so they do not encourage parties to go for ADR. I also talked about limited understanding of ADR by the parties, by by the common wananchi. They don't have a good understanding of ADR. So when a lawyer proposes mediation, when a lawyer insists on ADR, he's looked at as a soldier who is not brave enough for the war. They like to see that battle of words in court. So it's about understanding. But again, we do not have enough trained mediators and arbitrators. So the people we call mediators, you find them sometimes in the process, they find themselves doing arbitration, thinking they're doing mediation. So it's an issue of training. So we still need some training on these issues. But again, we have limited resources. I talked about a situation in Tanzania, for example, where in one of the situations when the government of Tanzania in 2022 wanted to have a center for arbitration, they wanted to put it within the premises of the High Court of Tanzania. And we told them, no, it's not a good place. So up to now, we do not have that facility for specifically for ADR. We use some places. It is upon the mediators, the arbitrators to choose where to go. And sometimes it is in hotels and where some parties may not be able to afford. So we have limited resources in that aspect. Thank you, Brenda. I have seen a question on the chat box. So Brenda will guide me on when should I respond to that. Thank you.
I've also seen it. We'll get to that when we are talking about opportunities. So,
Thank you, Brenda.
yes, now maybe we can get insight from the panelists, maybe the ones who have not talked about maybe their real life experience, of course, maintaining confidentiality, a case that you handled for an IP dispute where you refer the matter to mediation, I don't know, or arbitration. Mr. Patroba, do you want to go first?
Yes, I can go first. Unfortunately, a certain file landed on my desk. It was about basmati rice, and I think Leonardo Toscano, the WIPO might have to come and sort this out. This file was about basmati rice. It was Pakistan versus India. It has become so bad to an extent. I think we have seen even serious diplomatic wars among India and Pakistan. So this file that I have is Pakistan wants to register basmati rice. Already basmati rice, there are various products from India under basmati rice still in my database on the types of rice. So as a legal officer, sometimes you're unable to decide. The ambassador came to Kipi. She wants basmati rice Pakistan registered. The ambassador also for India wants basmati rice India registered. So such tough cases, if you decide, may lead to a diplomatic war ties. So what is the best option? You send it to international arbitration methods or mediation methods. So that is one major example. And it is a very, very serious issue that it has led to very constrainous relationships between India and Pakistan. I think, Leonardo Toscano, you should tell us the way forward and what WIPO has to say about India versus Pakistan. Thank you.
Yes, Mr. Toscano, do you want to go ahead?
Yes, of course. Thank you, Mr. Patrova, for sharing a real life experience. And yeah, look, we have seen cases where the parties agree to come to mediation at WIPO. This has happened, for example, in cultural heritage matters, traditional knowledge, geographical indications. We're still dealing, with parties that are not between countries, right? Like that would be more the case of the WTO, the World Trade Organization. Here at the arbitration center, the cases involve parties that are from the private sector or parties that might be public but acting as private parties, like a research center or a university or a museum, right? So, but in any case, if there's agreement for parties to explore, for example, the possibility of having mediation, this is something that is always very much welcome. Finding the suitable expert with knowledge in the area, with all these soft skills to be able to guide the parties to find a win-win solution, right? So in that case, this is how it would normally work in terms where there's a dispute and the parties don't have an agreement, a contract, or any other document that says that they agree to participate in a mediation. So dispute is there, the parties can agree to do that. We also provide what we call good offices. This is assisting the parties from the procedural point of view. Of course, we cannot have any legal views or any legal assistance or act as mediators ourselves, but we're very happy to explain and to share all the relevant information to guide the parties to choose the most suitable mechanism to resolve the dispute. That's what I can say about this, Brenda.
Thank you so much. Mr. William, come back to you. Maybe you can give us some of the lessons that African jurisdictions can take from the global ADR landscape when it comes to IP.
Thank you, Brenda. I'm not sure if my sound is better, but just going forward, some lessons that Africa learned. To begin with, Africa, as far as history is concerned, Africa used to be an ADR continent. Africa used to solve its disputes through mediation. That is ADR. So Africa lost ADR when it had the introduction of courts and so forth. And my message to Africa would be, can we go back to ADR? We used to be there. We need to go back. We have seen that, yes, the courts have some benefits, but we also have seen disadvantages. We have seen parties having permanent enmity through after a matter is resolved in court, because there's no opportunity for a shake of hands, unlike ADR, where those old men under a tree, after reconciling these parties, they make sure that the end process involves a shake of hands. But again, on our judiciaries, I would encourage the East African, the African judiciaries to adopt a path for, having innovative ways of introducing and allowing ADR in our systems. Our national courts should also have ADR. They should incorporate ADR in their systems. This goes all the way into asking our governments to have laws on ADR. I see a movement. I see that movement, especially in East Africa, from 2000, 2020, 2021, 2023, 2024. There's that movement, especially in Tanzania, Uganda, and possibly Kenya. They are coming up with laws and policies on ADR. So I would encourage Africa to go that way, changing the systems, the legal framework, having the facilities for ADR, and so forth. Again, another way of doing it is to encourage, like what is done today, encouraging forums for discussion of ADR, encouraging debates on ADR, having lawyers attend these debates and grasp the essence of ADR as opposed to what they are used as litigation. You can see a student in a law school, they are aspiring to one day become a lawyer in court, to do the way James Orengo is doing, to do the way Patrick Pierre Lumumba is doing. They have seen those as their as their role models. They want to become that. But no, we can do it the ADR way, this time around. So we can change, we can adopt ADR. It is more cost effective and it pays more. If lawyers, a lawyer excels in ADR, arbitration pays more because you get your money in a shorter time. Mediation pays, you get your money in a shorter time. Unlike a court process where you are paid some amount and then you undertake that case for 3, 4, 5 years. You are not really making a profit. Thank you, Brenda.
Thank you so much. Mr. Patroba, another question I have for you are, what solutions exist to strengthen IP disputes, in your view, in East Africa and ensure fair compensation for creators amid weak enforcement, limited royalty tracking, and the absence of collective management systems?
Thank you for that question. First, I will go back to the issue of also ADR before I go to the specific answer on the question you've asked. Brenda, you are a prosecutor and you know what happens in our courts, especially with matters of ADR. We realize that most ADR disputes are handled by non-lawyers, people who do not have basic knowledge of the law. Unfortunately, I'm going to air our dirty linen in public. I am sorry. In Kenya, especially. So you might, in most cases, you find that the outcomes of these matters are not the desired outcomes, or these outcomes sometimes are not as pleasant. Coming back to your question, the best way is that we can enforce rights, especially on matters IP, is having being able to go public about IP. We need to realize that IP is the new form of property, whereby I do not need to, Africans, we are so much used to my property is this land, my property is this car. Africans, we do not realize that even our brain can produce an idea that can be our property and can be able to sustain us and can be able to give us income. So we need to be able to sensitize the public, especially on matters IP. Number two, we saw the other day in the newspaper whereby Kenya lost a lot when it came to, I think that article was here, where Kenya farms missed out on the EU funding for not registering IP rights. Basically, so many people have ideas, so many people have inventions out here, but are they registering? They're not registering. So at the end of the day, we lose again. And then when you see your idea, it is being used abroad in New York, you're like, that was my idea. But what if you registered that idea? So the major issue or the major hurdle that we are facing as Kenyans and as Africans is lack of registration and lack of knowledge. Brenda, what was the other question?
The question was on the solutions to strengthen the IP dispute resolution when it comes to the compensation for creators, and amid the weak enforcement, limited royalty tracking, and the absence of collective management systems that we have.
Exactly. All those are tied to lack of registration. And lack of registration puts you in a vulnerable position whereby you have no right to claim anything. Like we always say, if you sit on your rights, you have no right to claim anything. So in my opinion, the major hurdle that we're facing is lack of knowledge, and this lack of knowledge that leads to lack of registration of IP rights. Thank you, Brenda.
Okay, thank you. I think there was a question.
Just a small addition.
Okay.
Just to bring it much more locally so that people can understand. We had this man called Willis Raburu, the man who used to work on Citizen TV. He came to Kipi, and we registered his slogan called Big Man Bazoo. So we registered Bazoo, and he insisted there, and we registered Bazoo. And one day, Airtel thinks that they can use that name Bazoo in a poster on Mombasa Road. So Airtel goes ahead and says, Bonga na airtime ya mabazu. And what does Willis Raburu do? He comes and he complains. He goes to the High Court and he complains. And he gets compensation of 6 million shillings. At the same time, you see that is someone who knew his IP rights. And that is where he got a cool 6 million. How many Kenyans are sitting on their rights, on their inventions, on their slogans, on the even some have even decided to trademark their names like Bahati. So the major issue that here we are facing in Kenya is lack of knowledge and lack of implementation of IP rights. Thank you.
Thank you. Mr. Toscano, Paul Rotich has a question in the chat box. He's asking whether the WIPO mediation process is time bound, and if so, for how long, and the remuneration of the WIPO appointed mediators, if they are regulated or just agreed upon by the parties.
Thank you, Brenda. In terms of mediation, there is no time frames, right? So it very much depends on the parties. The typical steps in the mediations are filing the request for mediation, then appointing the mediator. Then the mediator may require some statements from the parties to better understand the case. And then there will be the meeting, the mediation meeting, where the mediator will work with the parties. There we have seen cases that went, for a couple of days. In most of the cases, the parties will reach a solution within one day. This could be sometimes a long process, a long day, where the mediator will have meetings like plenary sessions with the parties and separate meetings known as caucus with each party, which can be a good way of understanding better the positions and perhaps even receiving some information from the parties that may not want to be disclosed to the other party, always respecting confidentiality from the part of the mediator. But it's a mechanism that works very well in practice. So it depends. I would say that we can think of something between 2 and 4 months as average. It depends a lot on the parties, if it's an international case, if the parties are in a domestic dispute and they're able to arrange their schedule faster, the case can take less time. So it varies very much. In some cases, we have seen parties wanting to suspend the mediation and maybe restarting mediation after a few months. So it's a bit it's a wide range of possibilities. So no fixed timelines. And in terms of the fees, they very much depend on the case. So there's a schedule of fees that is an orientation, but of course then it will depend on the case, on the amount in dispute, of the expertise needed. Usually it's tied to the hourly rate of the mediator and the number of hours that the mediator will use in a case. We say that a typical case may take between 10 and 15 hours. the parties will cover the cost by half, so 50% each party. And that's something that can be negotiated and arranged with the mediator. So very flexible. And the idea is that cost should not be an impediment to access mediation, but at the same time, if there's an expert helping the parties to resolve the case, it has to be fairly compensated also to dedicate time and work to that particular case. So that's Brenda, my points on this.
Thank you. So I think Mr. William, you had mentioned there's limited understanding of ADR in IP matters. So I think now we can talk about the opportunities that are there. And we can start with a question that Edward had asked you earlier. How can law students or young professionals in Africa best prepare themselves for careers in ADR with a focus in IP law?
Thank you, Brenda. If I may start with the question of how young professionals best prepare. One, it starts with the training in the law schools. At that stage, I would say that a law student should have a mental bias to ADR at that level. Yes, you have all these subjects, you have all these other resolution mechanisms, but have a mental bias to ADR at that stage. Number two, apprenticeship. This is very important. Apprenticeship get connected to practitioners of mediation of ADR. When you are on leave, you are on a holiday, get hooked to good practitioners of mediation ADR back home in the city. So be connected to practitioners. Number three, I would just by way of insisting on the importance of ADR, I would really encourage lawyers to take that direction. That is possibly where the world is moving toward, because we have people who are getting understanding of the benefits of ADR. The more we go, as years go by, the citizens, the businessmen will be understanding the importance of ADR. So I would encourage the lawyers who the up-and-coming lawyers, the young lawyers, to really embrace ADR. Now back to the opportunities. There are opportunities, yes. One, I would think of the spirit of our national governments and even our regional arrangements. For example, in Tanzania and Uganda, Tanzania had its Arbitration Act, which really changes the landscape of conflict resolution in Tanzania. It insists on it introduces 4 forms of ADR: arbitration, mediation, negotiation, and reconciliation. So it is opening up the different forms of ADR. We have laws supporting that, and the government is supporting that. We used to only have court-annexed mediation, but now you can do mediation from any part of the country, any part of the world. You can do arbitration from any part of the world. A party can choose an arbitrator of his choice. So that is an opportunity. Countries are opening up. Uganda as well. I think it is 2021, 2022, Uganda came up with a policy, ADR policy, and they have undertaken different ADR forums. Chief Justice Forum, different forums where they are opening up for ADR. So I know Kenya is ahead of us. Kenya is ahead of Tanzania, Uganda, and possibly Rwanda, and obviously ahead of Congo, South Sudan, and so forth. So there are those, undertakings by our national governments to do it. But again, even at the regional level, I have been practicing the East African Court of Justice, and I know they have a slot for mediation and arbitration, and they are training the judges, they are training the personnel for that. So there have been a few cases which have gone through ADR in the East African Court of Justice. So really, the national governments, the regional systems are opening up for ADR. So it is for us to grasp those opportunities. Another opportunity is the level of awareness, especially to the businessmen. Okay, for example, arbitration is mainly for businessmen, so it is opening up. So the level of awareness is going up. So lawyers should move with that spirit and grasp ADR. So I would encourage that. Belinda, that is what would say about the opportunities. Yeah, you.
Okay, thank you. Mr. Leandro, okay, Edward had also asked, what are some of the skills or qualifications required to effectively serve as a mediator or arbitrator in IP disputes? This is mainly for someone with great passion, even serving in international stages like WIPO.
Thank you, Brendan. Thanks for the question. Well, here we have to think about what mediation is and what arbitration is, for example, right? In mediation, the parties will be looking for someone with soft skills that will help them to get closer and to try to reach a win-win solution. So of course, it's important to be an expert in the subject matter or to have knowledge of if it's a trademark dispute or a patent matter, to know about the legal implications and to know about intellectual property. That's the base. But at the same time, it's very important to be trained in soft skills, right? Theory of conflict, learning how to approach parties when they are, at very let's say, opposing sides of a dispute, and how to get them together and how to help them to find some sort of solution that they can live with. In arbitration, you're looking for skills that are similar to the skills of a judge, right? To analyze, to understand, to know very well the applicable law, to understand contracts, understand contract law, and see how to draft a proper award. So there are many courses that are provided by institutions like the Charter Institute of Arbitrators, for example, where you can learn about the process, about the how to draft a proper arbitration award. There are many formalities, there are many issues that are very important details in an arbitration that normally will require more like legal skills to be able to be an arbitrator. So these are the two angles and the two type of set of skills that you need to become a mediator or an arbitrator. Maybe I can also take the opportunity to talk about opportunity for young professionals through what we call the WIPO ADR Young program. And this is a forum, a network, and I'll put the link in the chat so any of you interested can join for free this community where we share different information, trainings. Soon we will have a competition, an essay competition for young professionals to get educated and to build capacity in ADR for IP. So I invite all of you to join. The process is very simple. You just need to complete a form and provide your profile, and then our internal committee will assess your application. And once you are in the ADR program, then you will receive through our newsletters all the relevant information and invitation to participate in events. I can also take the opportunity to share with you a link to an online workshop on arbitration and mediation that we will be conducting soon in the month of June. And this is also free of charge. So let me just get the link to this event, and you can register and participate in this workshop. You will, if you attend all sessions, then You will earn a certificate of participation, so it can be useful to build your profile and to better understand how ADR works in IP disputes. So I'm putting here in the chat, and you can join for free. There you go. Thank you, Brenda.
Thank you so much, Mr. Leandro. That is so kind of you. As someone who has done various courses with WIPO on IP, I'll be sure to register for this. So thank you. So we'll now be entering the Q&A session. Feel free to share your questions. If you want to speak, please raise your hand so that I might be able to unmute you. There was a question by Akelo Jennifer. She asked, are there any institutes that train mediators and arbitrators? There is. I think this is the right opportunity to talk about ELS is collaborating with the CIAB to have an introductory training on ADR and arbitration. So please, it will be happening on the 12th to the 13th of June, 2025. So you're encouraged to join. I can share the link, or the same can be, I think the same will be shared in email. If you have subscribed to the ELS email, this is one of the ways where you can start your training. And then there is Theophilus Kiprop. I think this is a question for Mr. Patruba. He's saying, he's asking about Bahati, the musician, registering his name as a trademark. So he's saying you kindly elaborate how this can happen when a trademark should be something unique, yet Bahati is a common name. Even he's referenced a judge of the High Court who has the same name. So maybe you can respond to that, Patruba.
That's a good question. What Bahati did, or what most people do, they normally come with their names in a form of a logo. And in a form of a logo, you can put any design, you can put any colors, you can put any form of makeup, you can put pictures beside it. So it is not necessarily that the name Bahati was registered, but it came in as a logo, or rather as an image in itself. So that is how Bahati was able to register his logo to represent his business. So not necessarily we are saying that Bahati's name was trademarked, but his business logo was trademarked. And his business logo, the moment you look at that image, it says Bahati. It is the same way this group of young people who sang Anguka Nayo, they came and we registered Anguka Nayo. So Anguka Nayo is not the name that we registered. We registered the logo or the slogan, and they had written it in a very stylish manner with some colors and everything. So I think you guys can understand what I mean. But the moment you see it, you'll say, hey, Anguka Nayo has been trademarked. But that is in a layman's language. But in actual IP sense, it is the logo that has been registered, not really the name. So even me myself, I can register the logo Patroba, but I use it as an image and put some add-ons and everything. Yes. So it is just a logo representing a business. Thank you.
Thank you for that. Thank you for the clarification. Is there anyone else with a question? If you would like to speak, you can just raise your hand so that I can unmute you and you can ask your questions to the panelists. Okay, it appears there are no questions. I hope we are all satisfied. This has been a very rich and eye-opening session, and I would like to really thank our panelists for their for this fruitful discussion. Thank you for sharing with us your experiences. And to everyone, thank you for showing up and being ready to learn. I hope you leave this webinar not just informed, but inspired to integrate ADR into your practice, especially when dealing with IP matters. So thank you. Please be on the lookout for the ELS emails for our next webinars, and I look forward to seeing you next time. Thank you so much and enjoy the rest of your evening.
Thank you, Brenda.
Thank you very much.
Thank you to you, our esteemed panelists, Mr. Toscano, William Kivuyo, Patrobo Mwenga, and Brenda Imelda Mkoka for taking us through this very wonderful session. We look forward to having more of these, and stay tuned for more of our capacity building sessions. Please ensure that you that link and registered for this wonderful ADR workshop that Mr. Tano has registered. We'll also share the same via our platform so that you're able to register for those who have not registered. Otherwise, thank you all. Have yourselves a very lovely afternoon. Goodbye and stay safe.
Thank you, Gabriel. Bye-bye.